morning, everybody, and thank you, Limor, for your very warm welcome, and thank you also to Mrs. Weiner and Professor Adin, who have left the room, but I thank them for their warm welcome, and it's really a pleasure and an honour to be at the David Weiner Centre, and I'm looking forward to this day. So my focus today is to give a brief overview of what's happening in Australia. I won't be able to cover everything, and I'm not planning to cover the various kinds of practicing certificates, if that's okay, Limor. Yeah. But I just wanted to start with a bit of an Australian context, because as several writers have said, in law, context is very important. Then a snapshot of the legal profession and what it takes to be admitted to practice in Australia, what sort of regulatory regime we have, how lawyers are disciplined, and throughout I'll be talking about current issues and also future directions for the profession. So in terms of the Australian context, let me start with a map of Australia, which is Aboriginal Australia, and this is the map of the First Nations of Australia in terms of the Australian landscape, and you can see the extent, I suppose, of our isolation in terms of we're a country, we're a continent, we're an island, and this was how the First Nation divided our country. However, in terms of translating into a legal context, it's virtually negligible. This is really how Australia is depicted in terms of 6 states and 2 territories. And this is probably a larger way of showing it, easier to see. And this is seen on our flag. And when Jerry Seinfeld came to Australia, he said it's the British flag at night. That's what he saw. But you can see on our flag absolutely no reference at all to our first people, but very strong references that are reflected in our laws towards the United Kingdom. And there are the 6 stars of the Southern Cross, which is the constellation that we see in the Southern Hemisphere, and the larger 7 pronged stars, and a little bit similar to Magen David, but not quite, and that is the 6 states and the 1 prong for the 2 territories. However, why is this important? I'll come back to it later. If you're going to sum up the Australian Constitution, I would sum it up in one word, and that is federalism, really, and that is the relationship between the states and the Commonwealth government, if you like, and that is a thread that comes out throughout the regulation of our legal profession as well. So let me really start with the end and the future direction and the current issues relating to the Australian legal profession really can be summed up as a struggle, a wrestle with professionalism. How do we achieve true professionalism? How, as lawyers, are we not mere service providers and true professionals with a service ideal, with a definitive role as standing between the citizen and the state, with involvement in public interest, which gives us our monopoly over legal services? How do we justify this monopoly? And quoting from a former Chief Justice of the High Court of Australia, Justice Gleeson, he said, "The conferring of privilege and the acceptance of responsibility are 2 sides of the one coin." And this 2 sides of the one coin really throws out the various duties and the various tensions in legal practice. And my colleagues Mary Ann Noon and Judith Dixon summed up the minimum requirements for a legal practitioner to be considered professionally responsible. And the fiduciary duties are important, duties of confidence, duties of to act in an unconflicted manner, competence, diligence, using the law as an instrument to further justice, not to bring about injustice, and to enhance justice and serve the community. However, notwithstanding those very noble ideals, the reputation of Australian lawyers is very bad within the Australian community. And quoting from an Australian Law Reform Commission report, litigants, overwhelmingly in the family law area, criticised lawyers for being unduly adversarial, for exacerbating conflict, for going for the jugular, for the misuse or not using ADR at all, not using the justice system to be to resolve conflict rather than to conflagrate conflict, and being greedy as well. So, the Law Institute of Victoria actually, in response to this public perception, has got a special project to try to enhance the reputation of the legal profession. Because in order to enhance the reputation of the legal profession, this will lead to elevating perceptions and to elevate the administration of justice. And in reading this report from the Law Institute, it starts off actually with a quote by Steven Spielberg, and talks about how that huge shark in the Jaws movie. Has everyone seen that movie from many years ago, the Jaws movie? He had this huge mechanical shark, and what did he had? He gave the shark a name, and do you remember what the name was? Bruce, because that was his lawyer's name. So he called the shark after his lawyer. All right. So just a few minutes going back to our constitutional framework, which will lead to the discussion about the regulation of the profession. In Australia, power is shared by the Parliament. I'm calling that the legislative power. The Parliament creates the law, the executive government administers the law, and the courts, the judicial, exercising the judicial power, interpret the law, and it's called the separation of powers for obvious reasons. Importantly, in terms of the importance of the legal profession to our legal institutions, the legal profession provides legal advice and representation to clients and is an important legal institution in our country. Moving on to how we are regulated as a profession. Upon Federation of Australia in 1901, the responsibility for the regulation of, just leant on it, gone too far. The responsibility for the regulation of lawyers vested with the state government and territories rather than the Commonwealth government. So this has led to specific statutory schemes in the various jurisdictions. So there's a plethora and a range of requirements for lawyers throughout Australia. There is not one uniform body of laws that regulates the profession. And just to give you an indication of how complex our system is, we have two hierarchies of courts, and the federal court hierarchy, and importantly for our purposes, the state hierarchy, and I'm drawing my comments on the Victorian court hierarchy in the state of Victoria because that's the state that I live in, and it's also a very large, dynamic and important state in our Commonwealth. Well, the tribunals of specialist jurisdiction hear matters of discipline relating to lawyers in Australia. All right, so brief overview. So this slide actually is quite a detailed history of the Australian profession, but just some key ideas. We inherited our system from the UK, and you know, I said at the beginning, our flag shows our link, very strong link with England, with the UK, with Britain and the laws of Britain, and we had a divided profession. In 1891, there is a fused profession of barristers and solicitors. However, people usually practice as barristers or solicitors. So I call myself a solicitor. I haven't been called to the bar. I've never practiced as a barrister. So just a few words on that. Importantly, 1946, the Law Institute given powers to make regulations, so a delegated power to make rules, conduct rules relating to professional conduct. A few words on barristers, because I suppose you find this quite interesting. I'll just gloss over that. And I'll talk about the cab rank rule later because that's quite interesting. So, senior barristers were appointed as Queen's Counsel. Then the name changed with our Labor government to Senior Counsel because the referencing to the Queen was not well regarded. Now it's changed back with our Conservative government, which I think is quite funny. In terms of the range of legal services provided in Australia, I'll show you some tables in a few minutes, but the bulk of lawyers' work really in Australia is transactional work. It's not court-based work. However, the conduct rules really zoom in on advocacy. So a lot of our rules relate to the type of practice that only, say, 25% of lawyers are engaged with. So that is, I suppose, a remark and perhaps an issue for the future. And this table is a circle showing the providers of legal services, and what you can note over there is that although we as lawyers have a monopoly on engaging in legal services, there are a variety of non-lawyers that provide legal services. I've got paralegals, patent attorneys and others, and the others might be accountants, migration agents, etc. So we have solicitors in private practice, we have academics, corporate lawyers, and that's what it means to have a corporate certificate. If you're working for a corporation, then you have a corporate practicing certificate. Solicitor advocates who do court-based work, but also barristers who do the bulk of court-based work. We have the legal aid, community, government work, partnerships and private practice. Got a range of stats relating to the makeup of the profession. Around 100,000 people employed in the industry, and it contributed over nearly $11 billion to the Australian economy in that particular year. Many more solicitors than barristers, and nearly 2,000 in the legal aid sector. In terms of gender, males do dominate, but are particularly dominant at the bar. So you can see the figures of women at the bar are fairly low. However, there are quite a few women who practice as solicitors. In terms of earning capacity, partners in elite firms earn an average of $550,000 a year, compared to 40% of Victorian solicitors who would be earning less than $50,000 a year. So huge range of earning capacity, which I suppose is what you would expect. As I said, most practitioners are not engaged in courtroom advocacy. There is a trend towards specialisation, and there is also a huge amount of work relating to ADR practices, because ADR is mandated in all jurisdictions, in all most aspects of the civil justice system, in all aspects of the family law system. So increasingly, lawyers' work is involved in negotiation, mediation, etc. Most aged between 30 and 40, and significant growth in the profession. New law schools coming up all the time, seeing this as an industry in Australia. So we're churning out a lot of people with law degrees, and
if you call this one a significant growth, you should see the numbers in Israel.
Yeah. Huge in Israel as well.
If you call this is a significant,
okay,
in Israel it's skyrocketing.
Okay, that's interesting. Yeah. Where are the graduates going? The trend is to corporate. Okay. Similar in Israel?
Similar.
Yeah, okay. And why? GFC. All right, so the law firms, private law firms, during the GFC weren't taking graduates, and...
What is a GFC?
Global financial crisis. Okay, so the downturn in the Australian economy impacted greatly on the law firms. You know, there weren't many deals being done. However, graduates, it's quite hard to get a job as a law graduate in Australia, but they're going to the corporate sector for lifestyle reasons as well, to get away from the billable hour, to get away from those timesheets, etc. So they're working in terms corporate lawyers, company secretaries. They often get that dual role as company secretary and company lawyers. All right, so looking at some trends again, Australian consumer laws applying to lawyers, so also nationalisation and globalisation of legal service marketplace. So a lot of the mega firms have come to Australia and swallowed up a lot of Australian law firms. And sort of when this started to happen several years ago, I said, well, I think this is going to end in tears. It is ending in tears, and sort of we're just in the midst of it at the moment. Growth of community legal centres is also an important change in Australia. All right, so that's all I'm going to say about the profession. Any questions? I'm going to move on now to the law of lawyering, if you like. Yes, Limon.
You just were speaking about the mega law firms. Where do they come from? The mega law firm that buys into small law firms?
Usually the UK.
The UK?
Yeah, a lot of the large, prestigious UK firms. Australia's seen, I suppose, as the gateway to Asia. So you've got this presence in Asia, and the way to link in to the growth in Asia is through Australia. I think that's the way they're seeing it, and they're using Australian law firms as a vehicle for that.
So you would expect them to need more Australian lawyers, but in turn you said that there is a cut down.
Yeah,
do they bring their own UK lawyers, or they just have using technology instead of lawyers?
Yeah, all of that, and I think there's also an economy of scale factor as well. But it is, I'm saying it's hard to get a job because we've got this growth of law schools. We're churning out lawyers, so it's not keeping pace, even though with this trend, even though the big law firms, say from the UK, are coming into Australia and merging, if you like. And the US as well. They're coming from the US as well, and swallowing up the Australian law firms, and that's the way it's going. All right, so moving on now to the law of lawyering. And what I think is interesting to note and keep in mind is in Australia, we have a common law system, but we also have legislation. And in terms of the law of lawyering, they are running parallel. So if there is a legislative regime in this legal framework, it has not abrogated the common law. The common law is running along nicely, and the legislation is running along nicely. So that maybe is something a little bit different from Israel. Is that right? Yeah, would be quite different. Okay, so what we've got is a range of legislation and common law frameworks. The first one that I would mention are the regulatory regimes. In Victoria, we have the Legal Profession Act, and we have delegated legislation as well, so we have rules and regulations as well, so it's a huge amount of legislation. The national law is something that I'll speak about in a few minutes, and that is something that is going to crop up throughout my presentation because it is part of the current framework, it is a current issue, and it is also a future direction, so I'll get back to that. We also have throughout Australia quite recently, since about 2010, the enactment of civil procedure acts at state level and at Commonwealth level, which requires all stakeholders in civil litigation to use ADR and to use ADR with bona fides, to also act with civility. So there's this tension, isn't there, always as an Australian lawyer. Number one, to act in the best interests of your client. Number two, to act within an adversarial process, but on the other hand, to act with civility and also in the interests of the administration of justice. All right, so these civil procedure acts have been aimed at curbing adversarialism, because I'll be talking about a case in a minute. Adversarialism in some instances has gone absolutely mad, all right? The other frameworks are the Australian consumer laws, which regulate and proscribe misleading or deceptive conduct, unconscionable conduct, and unfair terms in terms of anyone acting in trade or commerce, including lawyers. Now, in the private sphere, contractual frameworks, common law relating to contract, common law relating to torts, as well as legislation, the Wrongs Act, And something that I think is a huge issue in Australia are the advocates' immunity. Just spend a few minutes on that because we are the only common law jurisdiction left which retains an immunity for an advocate in all court-connected work. All right, so just maybe stop for a minute and sort of garner some thoughts in the room about what you think about that. So there is no tortious liability. You cannot sue your lawyer if your lawyer, whether he or she is a solicitor or a barrister, in an action relating to court-connected work. And there have been various decisions, even at the level of the High Court of Australia, but a fairly recent decision is the 2012 decision of the Victorian Supreme Court in the Goddard-Elliott case. So just any thoughts on that, or
what's the rationale behind it?
the rationale behind it? It is said that the litigation process has to finish at some point, and that if there was a negligence action against a lawyer in a court-connected case, then the whole case would be litigated in terms of establishing causation, etc. Yeah. Yes.
Is there an issue of attacking a conviction based on inadequate counsel in Australia?
Yes. In the criminal.
Yes.
Yes.
Is that also opening the case again?
Yeah. Yeah.
Why,
so you're saying it's a little bit.
then?
Yeah. Well, perhaps one could argue that there is more at stake in the criminal sphere if you're talking about somebody's criminal responsibility, etc. Yeah. Okay. So we're standing there alone. I mean, it's very, very hard, I think, to justify. Yeah. Anyway, there we go. So in terms of our frameworks, contracts, torts, to a limited extent. The other thing I think is interesting is that in terms of Australian consumer law, etc., nobody knows about it because the contract of retainer, the retainer with your lawyer, does not spell that out, does not say, does not disclose that to the client, sort of saying, look, by the way, if this retainer relates to a court action, you have no recourse under the law of torts. Anyway, fiduciary duties that you're all familiar with, so I will skip through those. So in terms of the private law liability, contract and equity relating to the various principles at common law, even still relying on key English cases, and also legislative regimes such as the Wrongs Act relating to all professionals, not just lawyers. All right, so just as an illustration of the key duties relating to lawyers, just going through quickly our professional conduct and practice rules. The duty to act competently is key, and the standard can't be reduced. And we have a specialist's accreditation program at the Law Institute of Victoria. All right, so in terms of the regulatory regime, it controls entry to the profession, has a monopoly on legal practice, issues annual practicing certificates and CPD, and is responsible for discipline and punishment. And there are several institutions involved in the regulation of the profession: the Supreme Court, the Legal Services Board, the Legal Services Commissioner, the VCAT, I'll call it, the Victorian Civil and Administrative Tribunal, and the Professional Association. So that's the Professional Association of Solicitors and Professional Association of Barristers.
So it's basically an outside regulation, it's not
Yes.
regulation within the profession.
That's right.
Like we have in Israel, we have a very strong Israeli bar, which is mainly led by politician of the bar.
No, that
In
changed.
Australia, you don't, when was the change?
I think it changed in the 90s, in the 1990s.
We are still hoping for that change.
Okay, so the Supreme Court has an inherent power to discipline lawyers, and very importantly, when you are admitted to practice, you are admitted as an officer of the Supreme Court. So that underscores the importance of the lawyer's duty to the court and the lawyer's duty to the administration of justice. So the qualifications are determined by the Council of Legal Education, and applications for admission are considered by the Board of Examiners. The Legal Services Commissioner is the CEO of the Legal Services Board. So these are statutory appointments, and all complaints against practitioners start and end with the Legal Services Commissioner.
Who is sitting there?
Who is it? It's Michael McGarvey in Victoria at the moment.
Who appointed him?
How is he appointed? I think it's a government appointment, but I'm not sure. I'll get back to you exactly on how he's appointed. So the complaints are heard at the Civil and Administrative Tribunal, and the Law Institute of Victoria, or the Bar Council, draft the conduct rules. To practice law, you have to be an Australian legal practitioner. Only an Australian legal practitioner can engage in legal practice, and that is under section 2.2.2 of the Legal Profession Act. However, the legislation does not define what it means to engage in legal practice. So we've got a range of case law that interprets what it means to engage in legal practice, and the Lydia Marriott case is an example of that. And, from my point of view, the judicial determinations, such as in this Marriott case or another case, the Feldman case, are quite circular and unsatisfactory. They basically say engaging in legal practice is engaging in legal practice. So they never quite tell you what it means. All right, so what you have to do to practice law, you have to be admitted. That's a one-off event, and every year you have to obtain your practicing certificate.
Is that automatically, or you need to do?
No, you can do it online, and it's not automatic. No, you have to apply for it.
But you don't need to go and study or do?
No, you have to do your professional development. You have to have a certain amount of professional development each year. Okay. Yeah. And, I don't know if you're interested, but the admission process at the Supreme Court of Victoria is a very traditional Anglo-type admission process. You may want to have a look at that. So in terms of admission, you need to be eligible and you need to be suitable. And this is because you will be an officer of the Supreme Court. So you need your
What about foreign lawyers in international transactions in Australia?
Okay, if they are practicing in Australia, there are specific rules for foreign lawyers. Yes, there are specific requirements for foreign lawyers. Yeah, that's in the legislation. Yeah, I can talk to you about that later. Yeah. All right. So what you need is your academic qualifications and a period of practical legal training, and you also have to be of good reputation and character. You have to be a fit and proper person to practice law. So that's a very nebulous term, and it's being defined by the cases as you would expect.
What determines if you have a good reputation? In Israel, it's the same politician of the bar. They have a special committee that decided by politician of the bar, no outside regulation, no outside supervision, except the courts in some cases. If the people appeal, most of them do not appeal. In Australia,
Okay, so we're talking about admission to practice now, aren't we? So what you do, you need to, before you're admitted, give an affidavit, a sworn affidavit, to the Board of Examiners. That's what I had on the previous slide as one of the determinants of who determines whether you are a fit and...
Very close.
It's very close.
Very close to the rules in Israel.
Is it? Oh, okay. Well, I'll tell you a funny story. So you write an affidavit and you disclose all the terrible things you've done. So my students have to say, on this date I received a traffic infringement. On this date I used public transport and I didn't pay for my ticket. Okay, so I'm in my office one day and a student calls me and she says, I've got a friend who wants to know in the affidavit, should she disclose that she is a pole dancer?
That's funny.
Yeah. So the students get very nervous because, you know, sometimes you can't remember how many traffic tickets. Anyway, so the whole issue with the Board of Examiners is that it is incumbent on you to disclose matters which you think they think will be relevant. And there are a list of things that they tell you about, but the issue is about disclosure. If they're not happy with something in your affidavit, they will call you for an interview.
Who's they?
The Board of Examiners.
It's not the bar. It's
No, it's not the bar.
They are appointed by the Ministry
Yes.
of Justice.
Yes.
And out.
Yes.
Very different from Israel.
Yeah, the Board of Examiners. So just looking at some admission cases, question before the court, Supreme Court of Victoria, was whether conduct in the past and mental health issues would impact on admission. Yes.
I'm sorry, but it seems like the affidavit that the students gave the admission is very with their goodwill to expose those certain things. How can you decide or know if they really put everything up there, or
That's right. Good
is
question.
there any way to know or any way to find a student when there is a growth of law faculties around Australia?
Yeah, that's very interesting. It is an honour system and nobody really knows what happens at the Board of Examiners, okay? But they require the law schools, for instance, to notify them if there has even been an allegation of academic misconduct. So even if there hasn't been a proven charge or any hearing relating to academic misconduct, but even if there has been an allegation of academic misconduct, the law schools have to tell do you also have to do that?
No, we wish.
Oh, because I could see that you're, yeah.
We were discussing it. We have a couple of paragraphs, but there's no obligation.
We have now an
Because of
obligation.
privacy, the laws will never submit this.
No,
this
we're
type of
required to
information.
do it.
You're required.
We're required. And even, and look, I'll just talk to you about some academic misconduct cases are key cases that have come up. Of the key case here, the second case, this was an interesting one. This guy did a master's thesis at one of the Australian universities in law, and it was pretty good. When he finished his master's thesis, he thought, oh, I'm going to submit it to a journal for publication. So he submits it to a journal for publication, and the editor of the journal found that the whole material had been plagiarised. So had he not submitted it to the journal, he would have got away with it. So I think that is quite interesting.
Did they allow him to practice?
No, struck him off. He was no, that struck him off. This case is one I think will interest you. All right, so here we've got two students and doing a combined degree of law and business. And in the business degree, one of the lecturers found that their work was too similar. All right, so he called them up and he said, your work's too similar. I think you've collaborated. I'll find the slide in a minute. And I'm going to give you 0 for that piece of work. The piece of work was worth, I think, 15% or 20%. Anyway, regardless of getting the 0 for that work, they passed the course, all right? And one of them, when they went to be admitted to practice, one of them disclosed it and one of them did not. All right, they didn't have a hearing. There wasn't an academic misconduct hearing or anything. It was just a lecturer saying, I'm giving you 0 for that piece of work. So one disclosed it and he was refused admission. The other one did not disclose it, got through, was admitted. Later it came out, they struck him off the roll.
Bit harsh. A bit
We have a
harsh.
similar case in Israel, but they never strike them off.
It was considered harsh. It was considered.
A person grows,
Gutman.
in life. He makes mistakes. It's
A person grows in life, makes mistakes, and also what bothers me about this is perhaps the lack of natural justice. When the lecturer said, well, I'm giving you 0, I mean, what happened there? There was no hearing, yet there was a determination relating to the rights of an individual in this particular instance.
But
So
is it forever? They can't be lawyers, these two?
no, they need to reapply. So when somebody is struck off, there are various conditions attached to it. Sometimes they'll say you are being, you cannot reapply, say, for 2 years, 5 years, 10 years, depending on the severity of what has happened. Yeah. So that's an interesting case. All right. So in terms of the Board of Examiners, candour is important. So as they feel that if you have hidden something and it comes out later that you have hidden something that you should have disclosed, then it is viewed very poorly and your punishment will probably be more harsh. All right. Oh, okay, I'm just going through. Sorry, I'm going to have to go through. Wanted to talk to you about the cab rank principle, which I think is fairly interesting and controversial now in Australia. If you are a solicitor, you can reject work. People come in, you can take work, you can reject it. The principle at the Australian Bar is that if you are given a brief, you take that brief. There are exceptions, of course, to that if it's not in your not in your expertise, if it is not in your fee bracket, if it is unconscionable for you to take that brief, you don't have to take it. However, the principle is that is protective of barristers because it protects them against unpopular cases, unpopular clients, all right? So that's the cab rank rule.
Are barristers allowed to sue for their fees?
Yes.
Because in England, and now still the case is, but for a long time.
They've changed that, yes.
And it also,
Yes, yes. All right, so complaining against a lawyer, two types of complaints. A civil complaint relating to a pecuniary loss or a cost dispute. ADR takes place, then the matter, the matter is, as I said, the Legal Services Commissioner takes on the investigation. Just want to say a few words about this because I think this is interesting. Been some litigation about whether a practitioner should have natural justice when a complaint is being investigated. Case law said yes, abrogated by legislation, so there is no right to be heard in that respect. So two types of complaints, civil and disciplinary, okay? No opportunity for ADR in a disciplinary matter if the Legal Services Commissioner sees fit, then the matter is taken to the tribunal. All right, I've got lots of statistics here, and I might just give you my PowerPoint that you for the things that I've got here. All right, so in terms of discipline, two key ideas: misconduct and unsatisfactory conduct. Misconduct, double-pronged. Common law still applies, and here we still have King's Bench case, and we have our legislation and the less serious unsatisfactory professional conduct. All right, and the Legal Services Commissioner will decide which one to go to. Okay, examples of misconduct: non-disclosure in ADR, so misleading the other side, if you like, in a mediation. Overcharging can be misconduct. Drafting a false affidavit. Not replying to an investigation by the Legal Services Commissioner. So if the Legal Services Commissioner wants some information from you as a practitioner, wants you to do something and you don't do it, could be misconduct. Non-payment of tax and misleading the court, making a false statement to a judge. Few seconds about this litigation, because this litigation involved a plaintiff who was represented by Slater and Gordon, and Lemore's interested in Slater and Gordon because they were the first law firm to list on the Australian Stock Exchange, and the litigation was taken against British American Tobacco, and British American Tobacco were represented by a top-tier Australian national firm. However, the firm really underscored the need to regulate adversarialism in the civil litigation process because they engaged in a raft of interlocutory proceedings that were sort of burdensome, time-consuming, expensive. As well as that, they did everything for the client. They did not exercise independent forensic judgment. Whatever the client wanted, they did, including this very dodgy document retention policy, which was really a document destruction policy, and the Evidence Act and the Crimes Act were later amended to take account of this. However, no misconduct charges were taken, no disciplinary matters. Action was taken by the Legal Services Commissioner against the lawyers for the defendant in this particular case. All right, so we need to query why. Since 2004, in terms of current issues, future directions in Australia, there's been a big move towards national legal profession for obvious reasons that I've been talking about throughout. However, only New South Wales and Victoria, the two large states where most practitioners are, have adopted the Australian Solicitors' Conduct Rules and the national law. So it is very, very rough sailing at the moment for a national legal profession. So we don't know what's going to happen about that. So just to finish off.
Judy, we could skip the questions. You could go until.
Well, I'll just finish off because I would like to have a little bit of a talk with everybody. Drawing on another former Justice of the High Court of Australia, Michael Kirby, what are we going to do about professionalism in Australia? So this is what I started off with, and this is what I want to end with. Law is a business, but are we still a profession? Is there any idealism left, or are we just concerned with money and the billable hours? And again, Brett Walker talks about the pressure of money. Money defines the most desirable professional attainments in private practice. And how do we balance business interests with ethics? How do we create a fair and just society in Australia? Do you get the justice you can pay for? What about issues relating to access to justice? And there have been a range, these are just some of the reports relating to access to justice in Australia, and they've had a range of recommendations, some of which are interesting, some of them are not, I suppose. All right, interestingly, I think, is the recommendation that the good faith requirement in ADR needs to be emphasised, and the use of ADR in its true sense has to be spearheaded. Increasing obligations on candour with the court, and perhaps specific rules for litigation in family law where there were the most complaints against practitioners, and discouragement of litigation that really abuses the process. Just to finish off my last few points, Limor, huge problems with mental illness in the Australian legal profession. The data says that 30% of lawyers will suffer depression. And
It's amazing. I mean, 1/3. Wow.
Yeah,
Almost 1/3.
not happy campers. And
And they still all go to study in law school.
and they still all want to, yeah, that's a very good question.
How do you know that's 40%?
Yeah, I suppose. So you're querying.
Hmm?
So you're querying the data. Yeah. Well, that's what the Department of Health has. That's right. And also know what is depression in terms of, could it be neck widening, etc.
Bipolar, or which kind of depression?
I know. Yeah,
You're
I know.
paralyzed, or you're just sad.
Okay, so maybe they're happier than we think, or healthier than we think. But nevertheless, it is perceived as an issue in terms of there are mental health issues, and Seligman actually has written about that, and querying whether the culture of adversarialism, the culture of the billable hour, the pressure of life in the law, if you like, adds to this anxiety and depression, other mental health issues, substance abuse, family law issues, etc. So it is, I mean, I understand your question, it is perceived though as a problem in Australia because of the long working hours and the personality of the lawyers, the A-type personality.
You know, in the US, they had similar figures. So they went and checked in the law school because they thought maybe all the people with the depression problem, with the depression potential, are going to law school. And then
That's
they found
right.
out that when they're going to the law school, they're okay.
Yeah.
First,
right.
third year is different.
That's right.
They're the average. Something along with the legal education and with working,
Yes,
practicing, caused this high number.
That's
They didn't
right.
come like this to the law school.
that's right. Okay, so just a few questions to finish off with. Should lawyers act as paid mouthpieces for their clients? Should they perform work that conflicts with their own ethical compass? Should they act for people and causes that they don't like or disagree with? Should they discuss the morality of outcomes with their clients or outcomes on third party? Okay, and really finally, issues that I think prompt thought for future directions, the legislation itself, the ambiguity in the legislation throughout Australia in terms of this, you know, very simple concepts such as engaging in legal practice, huge issue with the fiduciary duty and the issue of loyalty. How loyal does one have to be to a client once the retainer has been finished, once you have finished your contract? The advocates immunity, I think you can hear from what I'm saying, think that's a big issue. It's noteworthy that in the National Professions Australian Solicitors Conduct Rules, so that is the conduct rules that accompany the national model law, the duty to the administration of justice is underscored as the primary duty. So it is quite clear that when lawyers juggle duties, this is the ultimate duty, the duty to the administration of justice. And also, the new rules encourage civility and require civility. So I think and I hope that that is the direction in which we are heading. So thanks very much for your attention, and I'd like to take some questions or to engage in a conversation. So you've talked
Yeah, we have
about
time.
fine. Yeah, we have some time. Yes. No hard questions.
To what extent do the constitutional issues affect legal practice in Australia regarding lawyers' rights, clients' rights? Or is, I mean, I don't know much about Australian constitutional law,
Yeah.
but is there any impact there, or is it pretty much free of constitutional restraint?
Yeah, it's pretty much free. As far as I know, there haven't been many issues relating to constitutional law and the legal profession that would have gone to the High Court, which is the court that looks at constitutional issues.
I mean, just one example, I mean, in the US, the whole issue of lawyers advertising was purely constitutional. And there's nothing like that in Australia that would...
No, because we don't have a Bill of Rights in our Constitution. Okay, so our rights stem from the common law. But anyway, they could have been litigated, but they haven't. No constitutional law challenges in that regard. Yes.
Would you say the legal profession in Australia is scandalous? There's a lot of scandals in the...
Is enough.
Yeah?
Is it corrupt? Is it rife with scandals? No. No, I've got a lot of confidence in it. So I think the public, even though the perception of lawyers is bad, there is an underlying confidence. And when you speak to another lawyer, you accept the other lawyer's word, and I would say no, it's not rife with scandal at all.
So it works.
It works well. It's a good system. It's probably not a perfect system, but it works quite well, yes.
When the commissioner are considering one candidate that committed a felony, is it important or is it in his consideration if the felony is or is not of a nature of a moral turpitude felony?
You know, that's a really interesting question because an allied question is, so somebody's already in legal practice, so we're not talking about admission, but it is the same standard. Say somebody's in legal practice and they have, well, the example that was litigated to the High Court of Australia was a lawyer who was convicted of sexual assault of some children. I think they were his stepdaughters. And this was, I think, a very unusual case that went all the way to the High Court. The High Court said that that did not impact on his ability to practice law because it was not something that was with regard to legal practice, such as stealing money from a client. Maybe that's an isolated case, but is that the kind of case that you were talking about? You said moral, you know, morally reprehensible.
And he wasn't disbarred?
No, he wasn't. No, that's,
wasn't
yeah,
disbarred?
that's called a solicitor. No, he wasn't.
He was suspended for a couple of years or nothing?
Nothing. They thought that was okay. So, in terms of a fraud offence, if it had anything to do with honesty, anything to do with money, that is seen as being, you know, very, very reprehensible.
And sexual assault, no.
Well, maybe this was a one-off case, but it did go to the High Court of Australia, which is at the apex of our hierarchy.
Yeah.
You know, so that's an interesting case. Whereas you're cheating in an exam, no, then you're out.
In Israel, such a crime is of a nature of moral turpitude.
Yes.
Will bow you.
Of a nature of a moral turpitude, such a crime.
That's right, because I understand what you're saying, and you would say that such a person is not a fit and proper person to practice law. That person is not of good fame and character. But it's just one example that comes to mind because of your question. So it depends, all right? It depends.
Are there different standards of ethics for different sections of practice in Australia? And for different sections of population, let's say elder law and people with disabilities?
Not really. In terms of the ethical framework, they're set down by the professional conduct rules, and the bar has its own rules. There are certain rules that relate to advocacy, and there are special rules relating, say, to defence counsel. Defence counsel would be allowed to act in a more robust way, however, not in what you're suggesting. So the answer would be no.
Thanks. I know that Australia is one of the most progressive states when it comes to providing free legal information. The Australian Legal Information Institute and different initiatives of public legal education, PLE. And I was just wondering if you have any idea if these initiatives have influenced the legal profession in any way.
No, I don't know.
Because usually the arguments against this commission is, oh, if we'll provide the citizens with free access to legislation, then we won't need lawyers, right? So I'm just wondering.
Yeah, well, there has been a little bit of a trend to unbundle legal services. So if people can do a little bit by themselves, that is viewed quite favourably, in fact. Okay, so people are prepared to put up with that because of the high cost of legal services and the cutbacks in legal aid. And some of the judges, there have been some recent cutbacks in legal aid, very extreme cutbacks. And some of the judges have refused to hear cases where a person has not been legally represented. So that's interesting, but not really on point of what you said, yes.
Regarding the immunity that you discussed beforehand, is it personal between the lawyer and the customer, or is it more wide where is immunity for the law firm and the client? Means if there is
Like the third party, if the third party can sue?
if the customer can sue the law firm and not the lawyer itself, because the immunity is only for the lawyer.
Yeah, look, what would probably happen would be the client would be suing the lawyer and the firm, and then it would.
So the firms also have the immunity?
Yes, yes. If it was with that court-connected work, yeah.
A related question, why does people still go to study law school?
Yeah, well, that's.
You portrayed a very sad, in terms of incomes of lawyers. I mean, there's a big difference. I mean, the average salaries of the solicitors that you stated, 50,000. That does not sound a lot, I have to say, especially knowing the high prices in Australia and everything. So why are they still attracted to law school?
Well, people study law and they don't necessarily want to be a lawyer. So they study law as a pathway to a job in government or some kind of job in education or a variety of jobs. So there, I don't know, I haven't got the statistics at hand, but out of all the law schools, there would only be a certain percentage that would go out and actually get a practicing certificate. Many would not get a practicing certificate. They would see it as a humanities education, if you like.
It's a first degree, like in Israel, unlike US.
It can be. It can be. We have an LLB degree, which can be a first degree, and we also have a JD, which is a second degree, and it is going towards the JD.
Oh, really? There's a move to the JD?
It's a move to the JD, yeah, at the universities.
You said before that overcharging might be misconduct.
It can be, yes.
Can you please give us an example?
I think the example that I gave was either the Meeks case or the Cantwell case. I think the practitioner overcharged by 66%. And in one of the cases, they charged the time for wrapping a gift. They had to give somebody a box of chocolates or something, and they charged for wrapping it up.
It takes time.
It does take time. Yeah.
Okay, I would like to thank you very much.
Thank you.